If you have an I-130 pending right now, or you are about to file one, there is a January 2026 update you need to understand because it can change one thing that drives almost every family case: how USCIS decides what gets worked first. And when the order changes, timelines change. In the next few minutes, I am going to break down what a processing priority shift actually means, who is most likely to benefit, and what you should do right now to avoid getting stuck in delays that have nothing to do with the priority system at all. By the end of this video, you will have 3 takeaways. First, a simple way to tell whether your case is in a group USCIS tends to move faster. Second, the practical steps that reduce the chance of an RFE or a file transfer delay. And third, what signals to watch in early 2026 so you can adjust your plan without panic. Here is the part most people miss. When you hear faster processing, that does not automatically mean your relative arrives faster. For many families, the I-130 is only step 1, and other bottlenecks can still control the real timeline. So we are going to separate what an I-130 priority change can realistically improve and what it cannot. Now, let us talk about what changed using plain English. An I-130 is the petition for alien relative. It is basically the U.S. petitioner telling USCIS, "This is my qualifying family relationship, and I am asking you to recognize it for immigration purposes." Processing priority is the internal order USCIS uses to decide which buckets of cases to pick up first with the staff time they have. USCIS can shift that order for different reasons, like reducing backlogs in a category, meeting certain internal targets, or responding to workload changes. The key point is this: a priority shift is about attention and sequencing, not about changing who is eligible. It is not a new law by itself, and it does not automatically change the official requirements for evidence or the steps after I-130 approval. Bridge hook. This is where people get surprised and lose months. They assume the priority shift means they can relax on paperwork. In reality, when processing speeds up, weak filings get flagged faster too. Before we go further, we need to be careful with wording. Your brief says "just confirmed" and describes USCIS releasing a major I-130 processing update for January 2026, including new processing priorities and faster timelines, especially for immediate relatives. In a situation like this, there are 2 lanes: what we can verify from official USCIS communications and tools, and what is being reported or summarized in the immigration community. Because I do not have your specific USCIS link or memo inside this prompt, I am going to treat the concept as a reported USCIS processing priority shift and focus on what it would mean in practice and how to verify it safely. Here is how you verify any I-130 processing update without guessing. Check the USCIS newsroom for official announcements. Check the USCIS processing times tool for Form I-130 and your service center. And review any account messages or notices tied to your receipt number. If an update is real, you usually see some combination of those signals over time. Now, who is affected versus who is not? Let us put families into clear buckets, because this is where confusion blows up. Bucket 1. U.S. citizens filing I-130s for immediate relatives. Immediate relatives typically include a U.S. citizen filing for a spouse, an unmarried child under 21, or a parent when the petitioner is at least 21. These are often described as not being subject to the same numerical limits that apply to preference categories, which can matter for downstream steps like visa availability. If USCIS is prioritizing I-130s to reunite families faster, this bucket is commonly the headline group. If you are in this group, a priority shift could mean your petition gets reviewed sooner, RFEs come faster, and approvals may move more quickly compared to other groups. But I want you to listen to this next line. Even in this bucket, faster is not guaranteed, because case complexity and evidence quality still control whether your file is approvable on first review. Bucket 2. Green card holders filing for certain relatives. Lawful permanent residents can file I-130s for a spouse and unmarried children, but those cases often fall into preference categories. That means even if the I-130 is approved, your relative might still need to wait for a visa number to become available before the next step can be completed, depending on where the relative is and which process is used. So a priority shift at the I-130 stage can help you get an approval sooner, but it may not change the overall end-to-end wait if the next stage is constrained. Here is a quick myth versus reality moment. Myth: if USCIS speeds up I-130s, my family member automatically gets a green card faster. Reality: the I-130 approval recognizes the relationship. After that, the timeline depends on the path: adjustment of status inside the US, or consular processing abroad, plus background checks, interview scheduling, and in many cases, visa availability. The I-130 is necessary, but it is not the only clock. Bucket 3. Cases that are more likely to see limited benefit from an I-130 priority shift. This can include categories that still face other bottlenecks, cases with missing evidence, cases involving complex histories, or filings that trigger additional review. Also, if USCIS is prioritizing certain family groups, other family preference petitions could see less attention, meaning their pace stays the same or effectively slows compared to the prioritized group. That does not mean they are being denied. It means the order of work may not favor them. Bridge hook. Two groups are at highest risk of misunderstanding this and making a costly move. 1. People who book travel right after an I-130 approval, assuming the next step will be immediate. 2. People who change addresses or switch strategies midstream without locking down their paper trail. Now let us talk about what could happen to pending I-130 cases. This is the question I see constantly. If I already filed, do I get moved into the faster lane? In many operational shifts, USCIS does not require you to do anything special. They simply change how they allocate officers and how they pull cases from queues. So many pending cases may benefit automatically, especially if they fall into the newly prioritized bucket. But there are 3 common reasons a pending case does not benefit even when priorities shift. Reason 1. The case is stuck because USCIS needs something from you, like an RFE response, a missing translation, a missing signature, a missing fee, or unclear evidence of the relationship. Reason 2. The case is at a stage that is not being accelerated, for example, waiting for background checks, file transfers, or an interview slot in another part of the process. Reason 3. The case is in a category that is not part of the new priority, so it continues at its prior pace. Here is another myth versus reality. Myth: a processing priority shift means USCIS will stop issuing RFEs and just approve faster. Reality: RFEs can increase when USCIS pushes to finalize more cases because they need clean evidence to approve quickly. The fastest cases are usually the ones that were prepared well from day one. So why would USCIS do this in the first place? Let us keep it policy and process focused. Agencies shift priorities to manage backlogs and meet performance goals, to improve customer experience metrics, and to respond to where delays are causing the most harm, like separating families. USCIS also has to balance different form types and different programs. When one area is under strain, leadership may redirect resources. Another factor is transparency and reporting. USCIS has public-facing processing time estimates and publishes data in various reports. When those numbers get worse, the agency has an incentive to improve throughput in high-visibility categories. But here is the small detail that changes everything. Improving throughput is not the same thing as eliminating the backlog. It can mean they process more cases per month, but if more filings also come in, the net improvement may be smaller than people hope. And if demand surges because everyone rushes to file after hearing faster processing, that surge can create a new wave of delays. Now let us translate this into real-world consequences, because that is what you are here for. First, travel planning. If you are a petitioner and your beneficiary is abroad, an I-130 approval is not permission to travel to the US to live permanently. The beneficiary still needs the right visa or immigration status. If the beneficiary is in the US and planning adjustment of status, Travel can be complicated if they do not have the correct travel authorization for their situation. So the practical impact is, do not make travel decisions based solely on rumors that I-130s are moving faster. Second, work and timing. Many families are counting on when a spouse can work, when a child can age out of a category, or when a family can move. Faster I-130 processing can reduce uncertainty, but it does not remove other waiting periods. Third, documentation deadlines. If the next step is consular processing, you may need civil documents, police certificates, and financial sponsorship documents. Faster I-130 decisions can compress the timeline you have to get those ready. That is good if you are prepared, and stressful if you are not. Here is an example scenario to make this concrete. Example scenario number 1. A U.S. citizen files an I-130 for a spouse living abroad. They hear about January 2026 priorities and assume the case will be done quickly. They do not update their evidence packet when USCIS later requests proof of ongoing bona fide relationship. An RFE arrives and they scramble, respond late, or send disorganized evidence. The result is not just delay. The case now has extra review time. The lesson: if priorities shift and USCIS moves faster, you need to be even more organized, not less. Example scenario number 2. A green card holder files an I-130 for a spouse. The I-130 gets approved faster due to improved workflow. The family celebrates and assumes the immigrant visa step will immediately follow. But because this bucket can be subject to visa availability, they still face a wait before the next stage can complete. The lesson: celebrate the milestone, but plan based on the full pipeline, not only the first approval. Bridge hook. And in a moment, I will give you a simple checklist that works whether your case speeds up or not, because it focuses on what you control. Before that, one more important clarification. When people say new priority system, it can mean different things. It could mean USCIS is explicitly prioritizing immediate relative I-130s. It could mean they are prioritizing certain service centers, certain filing methods, or certain case types within I-130s, like standalone I-130s versus concurrent filings. Without the exact official language in front of us, treat the phrase as a shorthand for internal workflow changes. Your job is not to decode USCIS management charts. Your job is to position your case so it is approvable quickly when an officer touches it. Now let us get practical. Here is your do this and avoid this checklist for January 2026, especially if you have an I-130 pending or you are filing soon. Do this. Create a clean case file. Keep a single folder, digital and if possible printed, with your receipt notice, copies of everything you submitted, and a timeline of key dates. Do this. Check your USCIS online account and case status regularly, but do not refresh obsessively. Set a schedule, like once a week, and increase frequency if you are near typical processing ranges. Do this. Make sure USCIS can reach you. Update your address promptly if you move, and confirm your mailing address is stable. Missed notices create avoidable disasters. Do this. Pre-assemble evidence you might need quickly. If the relationship evidence is thin, strengthen it with additional documentation that shows an ongoing, real relationship, but keep it organized and easy to review. If the case involves parent-child relationship documents, make sure the civil documents are consistent. Do this. Respond to any RFE or notice quickly and completely. If you get an RFE, treat it like a checklist. Answer exactly what is asked, and label your evidence clearly. Avoid this. Do not rely on social media timelines as your only planning tool. Those timelines can be real, but they are not universal. Service center differences and case complexity matter. Avoid this. Do not make irreversible moves based on an assumption of speed, like quitting a job, selling a home, or overstaying a status. Plan for best case, but protect yourself for a slower case. Avoid this. Do not submit a messy or incomplete filing just to get in the queue. A fast queue with a weak filing can still lead to delay through RFEs. Avoid this. Do not ignore the downstream steps. If your beneficiary is abroad, Learn what documents are typically required later so you are not caught off guard. If your beneficiary is in the US, understand the difference between the petition stage and the adjustment stage. Here is the part most people miss. USCIS transparency tools can lag behind real operational changes. You might hear about faster decisions before the processing time estimates reflect it, or the estimates might move without your case moving. So what should you monitor in early 2026 to understand what is really happening? Watch point 1, the USCIS processing times tool for Form I-130. Look at your filing basis and the service center handling your case. Track it monthly, not daily. Watch point 2, your own case signals. If you see more frequent updates, requests, or transfers, that can indicate active reallocation of resources. Watch point 3, USCIS announcements and data releases. If USCIS is emphasizing family reunification and improved processing, you may see additional communications. Watch point 4, community patterns but filtered. If you see a broad trend across many unrelated filers, that can be informative. If you see one viral post, treat it as a data point, not proof. Another myth versus reality. Myth: if my friend got approved in 3 months, USCIS is now doing all I-130s in 3 months. Reality: 2 cases can be filed on the same day and finish months apart due to service center workload, evidence issues, background checks, and category prioritization. Now, what could happen next? If priorities really do shift toward immediate relatives in January 2026, we could see 3 likely outcomes. 1. Approvals for those cases become more consistent and predictable, with fewer extreme outliers. 2. Other family preference I-130s may remain steady or feel slower relative to the faster group. 3. There may be a surge of new filings because people rush to take advantage of perceived faster processing, which can create a second wave of congestion. We could also see USCIS refine guidance on what they consider a well-documented relationship file, which can influence RFE patterns. And if the agency is aiming to reduce backlogs, they may expand the use of centralized processing or other workflow changes. But again, do not treat this as guaranteed. Treat it as what to watch. If you are in a category where visa availability is part of your journey, also watch broader demand and scheduling realities at the next stage, because those can control the actual reunification date. Let us land this with a calm recap, because I want you leaving with clarity, not stress. Number 1. A reported USCIS I-130 processing priority shift for January 2026 is about which cases get attention first, not about changing eligibility rules. Number 2. U.S. citizen immediate relative petitions are commonly the group most likely to benefit from prioritization, but faster is not automatic if your evidence is weak or you miss notices. Number 3. Green card holder petitions may see faster I-130 decisions, but the total timeline can still be limited by later steps like visa availability and scheduling. Number 4. The best move right now is preparation. Clean documentation, stable contact info, fast responses to notices, and realistic planning that does not depend on a rumor. Number 5. Watch official USCIS channels and processing time tools for confirmation and trends, and use social timelines only as a secondary signal. If you want, comment with your petitioner status, U.S. citizen or green card holder, and who you are filing for, spouse, parent, child. And I will tell you what questions to ask and what to monitor next, in plain English. And if you find this helpful, subscribe and turn on notifications so you do not miss the next USCIS update breakdown. Most importantly, do not panic. A priority shift can be good news, but your best protection is still a well-prepared case and a clear plan.